Hi, good afternoon, everyone, and welcome to the Office of the Child Advocate's presentation on the Massachusetts Juvenile Justice System, Fiscal Year 23 Key Data Takeaways and Opportunities for Improvement. My name is Melissa Threadgill. I'm the Senior Director of Policy and Implementation at the Office of the Child Advocate, and I'm joined today by my colleague, Christy Palazzano, who's our Senior Policy and Implementation Manager. I want to take a moment to thank all of you for taking an hour on a sunny, beautiful Friday to join us to talk about the Massachusetts Juvenile Justice System. It always just absolutely warms my heart to see the number of people that show up for what could be a fairly dry presentation about data, but we will in fact try to keep it interesting. So thanks for being here. Christy, yeah, thanks. Next slide. So just to give you a preview of what we're going to talk about today, real quick, we'll just give you a brief overview of the Office of the Child Advocate and the Juvenile Justice Policy and Data Board, in case you're not familiar with either of those organizations. I'm then going to turn it over to my colleague, Christy, who's going to talk you through fiscal year 23 key data trends. And then Christy's going to kick it back to me. I'm going to talk about some of the opportunities for improvement that the JPAD has highlighted in our most recent report. And then just give you a little bit of overview of some of the projects that we're working on in 2024. We are going to do our best to hold some time at the end for question and answer. So if you have them, we will welcome those. You can go ahead if you have them and put them in the chat as we go. We will have folks monitoring the chat. And so if it's a quick question, we might be able to respond right away. And for larger questions, we will save those for the end. Next slide. Great. So real quickly, the Office of the Child Advocate is an independent state agency. We provide oversight of state services for children, and we also serve in an ombudsman person role. Our mission is to ensure that children receive appropriate, timely, and quality state services, with a particular focus on ensuring that our state's most vulnerable and at-risk children have the opportunity to thrive. We collaborate with the public and state and private stakeholders. We work to identify gaps in state services and make recommendations to the state, including the legislature, for improvements in policy, practice, regulation, or law. We also serve as a resource for families who are receiving or might be eligible to receive services from the Commonwealth. We operate a complaint line that anyone who has concerns about a child can call, and we're going to drop that information in the chat in case that might be of use to you. So the Juvenile Justice Policy and Data Board is chaired by the Office of the Child Advocate, which is what brings us here today. This is a permanent commission that was created by the legislature in 2018 as part of the Criminal Justice Reform Act. The membership of the board is set by statute, includes representatives from child-serving agencies from both the executive and the judicial branch. We have representatives from both the House and the Senate. We have representatives from advocacy organizations, as well as a parent representative. And the legislature charged the JPAD board with four things. First, evaluating juvenile justice system policies and procedures and making recommendations to improve outcomes. Second, collecting and reporting available aggregate juvenile justice system data. Third, studying the implementation of any statutory changes that impact the juvenile justice system, and sort of offering some thoughts on what worked, what might not have worked, and any further recommendations for changes that might be needed to improve the system. Next slide. So I'm going to do a couple of slides of overview just to give you some framework for what you're going to see today. So first off, the most recent report from the JPAD board looked at data from fiscal year 23. If you're not someone that talks in fiscal years, that's July 1st, 2022 through June 30th, 2023. The report is well over 100 pages and it includes the data broken down in as many ways as we could. That includes breaking data down by offense severity as well as type. So offense type tells us what types of offenses youth might be alleged of committing. So for example, a person offense or a property offense or a drug offense. Severity tells us the seriousness of the offense, typically measured by misdemeanor versus felony. We also, whenever possible, break the data down by the race or ethnicity of the youth, their age, as well as sexual orientation and gender identity. And in the report, we also break down the data at a county level, which can help us understand the way trends might differ at the county level versus the state level. We compare the fiscal year 23 data to three key points in the past that we think are really helpful for understanding the way things have changed over time. First off is we just look at fiscal year 22. So what changed over the past year, what's gone up, what's gone down. We also compare data to fiscal year 19. That's our best pre-COVID benchmark. We know a lot of things shifted within the systems during the pandemic. And so we like to go back to fiscal year 19 as a baseline to sort of see what's different since the start of the pandemic. And then finally, fiscal year 18 is our pre-Criminal Justice Reform Act benchmark. And that's really the benchmark we use to sort of identify what impact the law might have had in our system. Next slide, please. So speaking of the Criminal Justice Reform Act of 2018, it's been around for a bit now, but the goal of that legislation was to limit the number of youth coming into contact with the juvenile court. In particular, it said the goal of the law was to reduce the number of incidents resulting from children's unlawful or problematic behavior that resulted in a response from the juvenile justice system. It did that in a variety of ways, or attempted to do that in a variety of ways. It raised the minimum age of juvenile court jurisdiction from age 7 to age 12. So children under the age of 12 can no longer be prosecuted in juvenile court. It removed juvenile court jurisdiction for a set number of first-time lower-level offenses. It allowed judicial diversion pre-arraignment for the first time. It also established some new requirements for school resource officers, police, and school districts, and it revised some of the juvenile overnight arrest lockup procedures as well. Next slide. All right, before I hand it over to Christy, we always like to talk folks through what you might call the typical juvenile justice system process. I know that some folks on this call have been practicing in the courts for a long time, and this will be old hat for you. But for some folks that might not have that sort of day-to-day familiarity, we like to talk through some of the process points and the terms that you're going to hear in the rest of this presentation. So the process starts with an alleged delinquent offense. That typically leads to law enforcement contact. That contact could be an arrest. So that might involve handcuffs, the back of a police car, taking youth into physical custody. Or it might involve a summons, which is essentially handing the youth and their family a notice that says, hey, you need to appear at court at a certain date and time. As you can imagine, those experiences are really different for the youth involved. Regardless of how that comes through, whether an arrest or a summons, the complaint's brought to the juvenile court, and the clerk will issue a delinquency filing if they find that there's probable cause for the offense. If the district attorney so chooses, they can then charge a youth at arraignment. And this is a really important point in the process because this is a point at which youth have officially a record. Arraignment appears on juvenile court records and can have impacts later in a youth's life. And so we tend to think of everything before arraignment as our opportunity for a diversion. And you'll hear us talk about diversion a lot in this process. And there's a lot of different little mini points in the process where diversion can happen, but all of that is really prior to arraignment. Following arraignment, we'll have pretrial proceedings that can include detention. So typically the youth would be held in a locked facility run by the Department of Youth Services, or it could also involve pretrial supervision, which is provided by the probation service. Once a case reaches disposition, this is the point where a judge or a jury, depending on the circumstances, determines if the youth is to be adjudicated delinquent. In the adult court, we would call that found guilty. Or not, so found not guilty. A case could also be resolved by what's called a quaff. That stands for continued without a finding. And this is a way of keeping a delinquency off of a youth's record and sort of resolving it in a more informal way. A youth on a quaff will typically still be supervised by probation for a period. And if that supervision goes successfully, the case will be dismissed. And then finally, if a youth is adjudicated delinquent, a judge will determine the sanction, which again could include nothing. There are cases that result in no sanction, but most times it will involve probation supervision or a commitment to the Department of Youth Services. All right, and now I'm going to turn it over to Christy to talk about key data takeaways.
Thanks, Melissa. Good afternoon, everyone. My name is Christy Polizano. I'm the Senior Policy and Implementation Manager at the Office of the Child Advocate. As Melissa mentioned, I'm going to walk you through some of the key data from the JPAD board's annual report last year. As Melissa mentioned, it's an extensive report with way more data in it than I'm about to present, but we'll give you the high-level takeaways from that report. Starting with the process points that Melissa just went over, we wanted to start grounding this conversation in snapshot data of what happened in 2023 in the juvenile court process in Massachusetts. So this graph here shows you the numbers of cases at each juvenile court process point that Melissa just spoke about. So there was just over 10,000 cases that came through on an application for complaint. That's that first step of the juvenile court process. From there, court magistrates filed around 6,600 delinquency filings. Of those, just over 4,000 were arraigned. So there's 4,025 arraignments in juvenile court in 2023. And again, that's when youth officially get a juvenile record in Massachusetts. From there, about 1,700 were disposed. And so that can include youth who were adjudicated delinquent or found guilty of the alleged offense, or adjudicated not delinquent or not guilty. It also includes cases that were resolved with a continued without a finding, and those are kids, as Melissa mentioned, that were supervised by probation. Of all of the youth who were adjudicated, that were disposed, 608 youth were adjudicated delinquent in 2023 or found guilty. And we'll dive into each of these process points moving forward. I said we're going to try to keep this data high level, and so throughout we have given you all some key takeaways from the data that were presented in last year's annual report, and this is our first one. So the numbers that I just showed you actually represent an increase in the use of juvenile justice system in Massachusetts in 2023 compared to 2022. And if the recent rates of increase continue from last year, the state can see a return to pre-Criminal Justice Reform Act numbers in the next 1 to 2 years. And I'll go ahead and break that data down in just a second for you all. So for the second year in a row now, we've seen an increase in juvenile justice system use in Massachusetts. And this chart here breaks down the percent increase at each of the juvenile court process points that I just spoke about between 2022 and 2023. So as you can see here, this increase begins at the initial stages of the system. So at the application for complaint stage, we saw a 14% increase in system use, and continues through all major court process points. So there was a 23% increase in the number of delinquency filings in 2023 compared to 2022, a 34% increase in the number of arraignments compared to 2022, and a 32% increase in the number of dispositions in 2023 compared to 2022. As I mentioned, if the recent rates of increase continue, system use will revert to pre-Criminal Justice Reform Act levels in the next 1 to 2 years. So even though the number of cases of youth entering and moving through the juvenile justice system in 2023 is lower than 2018 still, they are on an upward swing here. So this chart here breaks down 2018 data compared to 2023 data. So the blue bar here is fiscal year 2018 numbers at each major juvenile court process point, and purple represents 2023 data at each juvenile court process point. And this dotted line here uses the rate of increase between 2022 and 2023 to project out, okay, if this rate of increase continues into 2024, which is our current fiscal year, what will the numbers look like? And you can see that from almost all of the court process points, numbers will at least meet or exceed pre-2018 levels. And 2018, like Melissa mentioned, we use that year as 1 year prior to the passage of the Criminal Justice Reform Act to see if that law is having its intended effect, which by and large was to keep youth out of the system as much as possible, especially regarding lower level offenses. Which leads us to our next takeaway. We wanted to dig in to see what's causing this increase at what process points. What can we dig into across all process points to see what's contributing to this increase? And we can see in the data that the increase really starts with an increase in the number of arrests for youth, and specifically for lower level or misdemeanor offenses. And we can see this increase continue through other custodial settings of the juvenile justice system. So I'll break this down a little bit more. So as Melissa mentioned, youth can enter the juvenile court either via an arrest or a summons, a court summons. Massachusetts police training, as well as common law, says that a summons is the preferred method for bringing youth into juvenile court, considering a custodial arrest and the traumatic effects that can have, especially on youth. A summons is a preferred method. So this chart breaks down how youth are entering the juvenile court. And so the blue part here is the number and percentage of cases that are coming into the juvenile court via an arrest. And the purple on the top here are the number and percent of cases that are entering court via a summons. And if you come over to fiscal year 2023, you can see that actually this was the first year that there was a greater percentage of cases coming in as a result of an arrest compared to a summons. All previous years, summons, more youth were coming into court via a summons compared to an arrest. And actually, between 2022 and 2023, the number of youth coming in on a summons decreased. So not just the percentage of youth coming in on a summons, but also the number of summons issues actually lowered. So the increase between 2022 and 2023 really stems from this increase in arrests. When we looked at this further, we said, okay, what's going on with the offense severity for youth coming in on arrest? And we saw that compared to fiscal year 22, arrests for misdemeanors, those are those lower level offenses that Melissa was speaking about, increased by about 85%, while arrests for felonies, more serious level offenses, increased by just 20%. So this top chart here, talks about the arrests for misdemeanor offenses. And we could see between 2022 and 2023, there was a large increase, 85% of cases that were brought in via an arrest. And again, this is for misdemeanor or lower level offenses, compared to this bottom chart here, breaks down the arrests for felony related offenses since 2018. And we can see between 2022 and 2023, there was an increase in arrests for felonies, which makes sense when we think of the type of offenses that fall into felonies. If they threaten public safety immediately, those are the ones that police will tend to resort to using an arrest. Those increased 20%, but again, not as much compared to that 85% for misdemeanors. And as I mentioned, this increase at the front door of the system for misdemeanor offenses and lower level offenses, we saw that carry through other custodial settings throughout the juvenile justice system in 2023. And so we can see here that 85% in misdemeanor arrests that I just spoke about also contributed to a 27% increase in lower level offenses coming in for an overnight arrest admission. And that's youth who are who are arrested and detained until the next court business day. It also contributed to a 35% increase for lower level offenses for youth who are detained pre-trial. So these are youth who are awaiting their trial and are held in a DYS detention facility in the meantime. And we'll dig into that number in just a second, as well as there was a 51% increase in the number of first-time commitments for lower level offenses as well. And this is between 2022 and 2023. So the board looked at this data and specifically lower level offenses. We also dug into this 35% increase in pretrial detention, citing the research that shows, again, that custodial settings and the negative impact that can have on youth, and really trying to limit the number and percentage of youth who are in those types of settings, which leads us to our third takeaway. In 2023, data show that youth who are being detained pre-trial have potentially unmet needs, and compared to 2022, those needs seem to be greater and worsening. So in 2023, youth detained had higher rates of behavioral health needs, educational challenges, and in some cases trauma, including an increase in the percentage of youth who have current child welfare system compared to 2022. So I'll dig into that data. So youth can be detained pre-trial for a number of reasons. They can be detained with or without the opportunity for bail. So if youth are detained with the opportunity for bail, youth and their families can post a cash bail and abide by certain stipulations and conditions if they are released pending their case. Youth can also be held without bail. And as you can see from this chart, most youth in Massachusetts, it's this blue bar here, when they are detained pretrial, they're held without the opportunity for bail. Youth can be held without bail for a number of reasons, and this chart breaks down why youth might be held without the opportunity for bail. Number one, they might be held as a result of something in Massachusetts called a 58A or a dangerousness hearing, and that is a court process that determines youth are a danger to themselves or the community and therefore will be detained pending their trial. And that's that light blue chart here. So in 2023, about 20% of kids who were detained pretrial were detained as a result of a 58A or dangerousness hearing. Youth can also be detained as a result of their bail or personal recognizance being revoked. So youth can, like I said, post their own bail, post bail, and then have to abide by conditions of release while they are pending while their case is pending. And so if they violate any of those conditions or pick up a new charge or are arrested again, they can be detained on the underlying offense. And by and large, that makes up most of the detention admissions from fiscal year 21 on. So in fiscal year 23, 42% of detention admissions were for youth who were detained as a result of their bail or personal recognizance being revoked. These were youth who were out in the community who violated conditions of release or picked up a new charge and were detained. Compared to fiscal year 22, youth who were detained for whatever reason, whether it was a dangerousness hearing or their bail was revoked, they had higher rates of behavioral health needs and educational challenges, and in some cases reported higher rates of trauma in 2023 compared to 2022. For example, in fiscal year 23, more than half of the youth detained pretrial had an individualized education plan or IEP, which is about twice the rate of Massachusetts students generally. A quarter of the youth detained pretrial had previously experienced physical or sexual abuse or had been sexually exploited. And about a third of youth detained pretrial had identified feelings of depression or anxiety, which is about twice the rate of Massachusetts youth population. Meanwhile, length of stay that youth are spending in pretrial detention also has increased over time. So on average, in 2022, youth spent about 63 days in detention, and in 2023, that was up to 69 days in detention on average. So just over 2.5 months or so. And as I mentioned, half of all pretrial detention admissions were for youth who were involved with DCF, which is Massachusetts Child Welfare System or agency, at the time of their detention admission. So this chart breaks down 2022 and 2023 data. And we can see in both fiscal years, at least half of all detention admissions were for youth with child welfare system involvement at the time of their detention admission. So in 2023, 51% of all detention admissions were for youth with DCF involvement at the time of their admission. And when we looked at the change from 2022 to 2023, that increase that we saw across all detention admissions really stemmed from an increase in the number of youth who were detained pretrial who had DCF involvement at the time of their admission. So for every 3 additional admissions in 2023 into detention, 2 were for kids who had DCF at the time of their admission. Which leads us to our fourth and final data takeaway for you all today. The board looks at racial and ethnic disparities data every year in our juvenile justice system. And this year, the board noted how that racial and ethnic disparities are particularly stark at the beginning of the system and are worsening at other points throughout the system. So racial and ethnic disparities are largest at the beginning stages of our juvenile justice system in Massachusetts, particularly looking at how youth enter the juvenile court process and how that matters. As I spoke about earlier, arrests for misdemeanor offenses are increasing. And we also see disparities in the way youth are entering court via an arrest versus a summons. So in 2023, compared to white youth, Black or African-American youth were just about 3 times more likely to enter the juvenile court via a summons, but about 5 times more likely to enter via an arrest. So much more likely to enter via an arrest than white youth. Similar trends exist also for Latino youth. So Latino youth were about 2 times more likely to enter the juvenile court via summons and about 3 times more likely to enter via an arrest. And as I mentioned, in juvenile court, the summons is the preferred method for bringing youth into court, considering the traumatic nature and negative consequences arrests can have, especially when they are for lower level offenses or avoidable reasons. We can see that these disparities also exist between youth of color and white youth throughout other process points as well. And in certain situations are getting worse from Criminal Justice Reform Act implementation. So compared to fiscal year 18, the disparities between Black and white youth across custodial process points are worse. So stick with me here. This table breaks down a little bit of wonky data, but what I want to draw your attention to is this second chart, or the second column here. This is the rate of disparities between Black and white youth in 2023. And this first column here is the rate of disparities between Black and white youth for 2018. And you can see across all the custodial process points. So that's an arrest, an overnight arrest admission, a pretrial detention admission, commitments and first commitments to DYS. We can see disparities have actually gotten worse over time. So I just spoke about arrests. For detention admissions, for example, in 2018, Black youth were 1.5 times more likely to be detained pre-trial than white youth. And in 2023, they were 2.34 times more likely than white youth to be detained pre-trial. So disparities are getting worse across certain process points in our system for Black youth. For Latino youth, it's not across all custodial points, but there are points in which disparities are increasing since 2018. So for overnight arrest admissions, Latino youth in 2018 were 1.5 times more likely to be admitted overnight into detention. But in 2023, they were 2.79 times more likely than white youth to have an overnight arrest admissions. Similarly, for pretrial detention admissions, in 2018, they were 1.71 times more likely than white youth to be detained pretrial, but that number increased in 2023 to be 2.55 times more likely than white youth to be detained pretrial. So disparities worsening for Latino youth at certain process points throughout the system as well. So these are our 4 takeaways that the board noted in last year's data rather. We noted that there was the increase in juvenile justice system in Massachusetts in 2023 compared to 2022. And if those recent rates of increase continue into this current fiscal year or next fiscal year, we will be at pre-Criminal Justice Reform Act numbers. We saw that this increase really starts with arrests and starts with arrests for misdemeanor or lower level offenses. And we see that continue throughout other parts of our juvenile justice system with lower level offenses increasing. We saw that youth detained pretrial have potentially unmet needs, and compared to 2022, are experiencing worse behavioral health concerns, educational challenges, and in some cases trauma than in 2022. And we saw that racial and ethnic disparities are particularly stark at the beginning stages of our system and persistent year over year, and in some points getting worse at other points in the juvenile justice system. So I'm going to hand it back over to Melissa, who's going to talk about the optimistic way we can be using this data for opportunities for state improvement.
Great. Thanks, Christy. I'm going to go to the next slide. All right. So as you probably gathered from Christy's presentation, there is a lot to be concerned about in the trends that we're seeing in the data. And this year's report was, frankly, a less fun report to write than in previous years, because for a number of years following the Criminal Justice Reform Act, we were able to say the data is headed in the right direction. We were able to sort of celebrate that success and think about how we sort of continue to push forward in the right direction. And that is not what we're seeing this past fiscal year. And so there's a lot to be concerned about. And so really thinking about the data that Christy presented, we want to highlight 3 recommendations that the board has made in recent years that we think would help address some of these trends. And I'm going to talk about each of these in more detail, but just to give you a high level, we recommend addressing the policies and practices in the state that are contributing to ethnic and racial and ethnic disparities in the juvenile justice system. We recommend increasing opportunities to divert youth away from the system prior to court involvement. And then finally, improve the triaging of and access to supports with unmet needs, whether those are behavioral health or educational or addressing experiences of trauma that might help address some of the behavioral issues that are then leading to juvenile justice system involvement. So next slide. So first, we're going to talk about policies and practices in the state contributing to racial and ethnic disparities. So the board took a deep dive onto this subject in 2022, and we issued a report that I know Morgan will pop into the chat in a moment, really focusing on the front door of the juvenile justice system. Because as you heard from Christy, that's really where the disparities start and where they are most acute. And so in that report, we looked at with the data we have, which to be clear is limited, but we looked at the types of factors that we thought might be driving in racial disparities at arrest. And so we looked at the extent to which Black and Latino youth were coming in on misdemeanors versus felonies, the extent to which they were coming in on persons or weapons charges versus property offenses or drug offenses. Typically, people tend to differentiate between, assaults and gun charges rather than property offenses. And we also looked at some sort of geographic differences across the state. And what we found is that there are a variety of factors that are leading to racial and ethnic disparities, but it's clear that arresting behavior, sort of the decisions of law enforcement that are making arrests, is contributing to racial and ethnic disparities. We found that Black and Latino youth were more likely to be brought in on an arrest rather than a summons, regardless of the type of offense they were charged with or the severity of the offense. And we go into a much deeper dive in that report, but it's clear that the racial ethnic disparities are real and could be addressed at least partially through changes in police behavior. It is the law of the Commonwealth that when a youth is alleged of a misdemeanor, that a summons is the preferred method of bringing that youth to juvenile court. That's in statute, and it's also what law enforcement are trained on through the Municipal Police Training Committee. And yet, as you saw in the data, we're seeing an increased use of arrest for misdemeanors. And so a lot of this we think could be addressed at the police department level. We looked at a variety of department policies. Many departments include language in their policies that state whenever reasonable and possible, an officer will request a summons for a juvenile rather than taking him or her into custody. There's a lot of room in reasonable and possible. And we would recommend that police departments provide more guidance and limitations on when an arrest can be used versus when to issue a summons, and frankly, when to offer diversion in the first place. Law enforcement have always practiced informal diversion techniques, right? Giving someone a warning is a form of diversion. That's within law enforcement authority. It's also within law enforcement authority to make a referral to a diversion program. And so we'd like to see departments leaning in on that more and providing some more guidance so that we can reduce both the disparities in the arrests, but frankly, just the number of arrests for misdemeanors in the first place. So that's one recommendation the board has made. We want to move to the second one. All right, this is my favorite topic. Anyone who's heard me talk knows I love to talk about diversion. The reason I am so passionate about diversion is because research shows that it works. There have been a number of studies now that look at youth who were on the edge. They could have been prosecuted in the juvenile court, or they could have been served in the community. And this research follows these youth and sort of sees, well, what were the outcomes? And this research is really clear that youth who are diverted from the juvenile justice system report less exposure to violence, higher rates of school enrollment, this is my favorite, higher perceptions of their own opportunities, right? They can see a better life for themselves when they go through diversion versus not. And then, of course, always of interest to anyone who cares about public safety, which is probably all of us, they're less likely to be rearrested. So we know that high quality diversion programs actually increases public safety and leads to better outcomes for youth. And that's why we are so passionate about diversion at the Office of the Child Advocate and the JPAD board. So next slide. So someone in the chat earlier, Joan, I think it was, asked if we have data on How many youth are referred to diversion programs? Unfortunately, we don't. Diversion referrals happen at the community level. Law enforcement, clerks, district attorneys, and judges can all make referrals to diversion program, and there's no one central place where that is calculated. What we do see is the number of cases that don't move forward to the next step in the process. And that's what this chart shows you. So this looks at the percentage of cases at individual process points that don't reach that final disposition stage. And so you can see that the blue line at the top is the percentage of applications for complaint that don't reach disposition. This number's been relatively stable since, certainly since fiscal year 20, 83, 84, 85% of those cases don't actually reach the disposition stage. When you get to delinquency filings, that drops down to about 74%. And then really interesting, to me at least, is the percentage of arraignments that aren't disposed. And so you'll see that over half of cases that are arraigned don't actually lead to adjudicated delinquent, not delinquent, or a quaff. These are cases that somewhere along the way are dismissed. And there's a number of reasons that cases be dismissed. I'm not going to get into all of them. And certainly there's lots of good reasons a case might be dismissed. But there's some number of cases in here that probably could have been diverted prior to arraignment rather than sort of held on for a period of time. Diversion allows us to get youth services faster, it keeps that arraignment off their record, and frankly, it frees up other resources in the court that could be dedicated to more serious cases. So that leads us to this next slide, which is, okay, we're saying yes, so we think there's more opportunities to divert. Where are these opportunities? Now, unfortunately, we don't have at our disposal, at least, individual case files that could allow us to go through and pick out and say, yes, this diverse youth should have been diverted or that youth. What we have is sort of broader strokes of the data. But we can see in fiscal year 23, there was an 85% increase in misdemeanor arrests. More than half of applications for complaint were for misdemeanors, and a little over a third of arraignments were for misdemeanors. That is some really excellent opportunity to think about an increase in diversion on those misdemeanor offenses, of which there are quite a few that are moving through the court system. Christy also talked at length about the significant racial and ethnic disparities we see in our system. So we know that Black and Latino youth are significantly more likely to have been arrested and move through the juvenile justice system. There are absolutely situations where Black and Latino youth are given fewer opportunities of diversion than white youth. We see it in the data, and there's, I think, really more opportunity to make sure we're being equitable in our diversion decisions. A couple other things, youth with DCF and involvement, as well as youth who have higher rates of behavioral health needs, educational challenges, and in some cases trauma. For those that are in the mental health field, we know behavior is language, right? And so often these behaviors that are leading to delinquency, arrests, and allegations are rooted in causes that if they're addressed, we could stop that behavior faster. So these are all examples of the types of youth that we think would benefit from diversion, and we think the system should work to divert more often. So if you want to go to the next slide, I would be remiss if I didn't take a moment to plug the Massachusetts Youth Diversion Program. So this is a partnership between the Office of the Child Advocate and the Department of Youth Services. And I see so many of our colleagues from DYS here today. Thank you for joining us. The diversion program was developed based on a recommendation made in the JPAD, made by the JPAD in 2019. And that over time led to the development of what was first a pilot. We called it a learning lab, and it's now a program. This is designed for youth with first-time and or lower-level offenses, as well as cases where a youth's unmet needs may be driving the delinquent behavior. And the program will accept referrals from anyone who is legally allowed to make a diversion referral, which includes police, court clerks, district attorneys, and judges. The program includes evidence-based intake and assessment processes, and then programs and requirements and services that are tailored to the individual needs of the youth. This is not a cookie-cutter program. We really tailor the program to each individual youth that comes to us. And the case management is provided by community-based organizations, and those organizations are also really well set up to connect that youth and their family to other services that might be helpful. So whether it's SNAP benefits or mental health services, things that may not be a requirement of diversion, but might really help support that family. So next slide. We're really excited about the growth of this program over the last couple of years. As of about a month ago, middle of April, we've received 526 referrals, of which we've successfully enrolled 382 participants. Of those, 270 youth have successfully completed the program, and another 82 are on track to complete the program in the coming weeks and months. We're going to be putting out a year two data report in the next couple of months, but I'll give you a little spoiler alert. In 2023, we had a 90% success rate of kids coming through the program, which we're really proud of. Our diversion coordinators work really, really hard with these youth. And you can see we've had referrals across the board. I think it's been particularly popular with judges and district attorneys, but we've had some referrals from police and clerk magistrates as well. All right, so if you are sitting here listening to this data and you're someone with a authority to divert a youth and you're thinking, gosh, I really want to, we are currently operational in 7 counties. We are up and running in Worcester, Essex, Middlesex, Hampton, Plymouth, Bristol, and Barnstable counties, Cape and Islands. And so really open for referrals in those cases. And I do see a couple folks here today that are referrers to this program. Thank you for your participation. We really appreciate working with you and look forward to continuing that partnership. All right, next slide. All right, and then finally, we make recommendations to increase support for the types of programs and services that research tells us helps prevent delinquency, supports positive youth development, and address pandemic-fueled effects. Research is really clear that the number one thing that helps keep kids away from delinquent behavior is positive activities with peers that aren't committing delinquency. And so what we really see, and we see this loud and clear in our diversion program, that if we can get kids connected to enrichment activities, mentorship activities, activities that promote academic success, vocational programming, life skills, and particularly for youth that might be gang involved, safety violence and safety planning and violence resistance. These are programs and services that are in the community that can help keep kids away from the juvenile justice system, and we'd like to really see more increased support for those. All right, next slide. All right, so real quickly, and then we're going to have time for questions, and I see the chat going wild, so I look forward to seeing what questions we have to answer. Next slide, we're just going to talk quickly about the JPAD 2023-2024 projects. So if you're paying close attention to Christy, you probably saw there's a lot going on with pretrial right now. We're seeing some significant increases in the number of youth that are being placed on pretrial supervision. We're seeing some increases in pretrial detention. And I think most alarmingly, we're seeing those increases in detention coming from youth that haven't been successful in this pretrial period if they're violating commissions or picking up new arrests. And so we're really doing a deep dive to identify what can we do to help prevent pretrial detention? What can we do to help youth be successful during this pretrial period? And so this is leading to 2 projects. One is a deep dive into the juvenile pretrial phase, and we anticipate having a report with some recommendations, hopefully later this year. We'll see how that goes, but that's the goal. And then we also have a special project focused on dually involved youth. These are youth with DCF involvement at the time of their detention. As you saw in the data, that's about half of the youth that are diverted, or excuse me, not diverted, youth that are detained each year. And so we're also doing a deep dive to better understand what's leading to detention for those youth, and are there particular policies and practices we can put in place to better support these youth that have already gone through so much in their short lives. All right, what else do we got? We would like to hear from you. If you saw that and thought, I have things to say about pretrial or dually involved youth, and we haven't already talked to you, please reach out. We would love to chat, hear about your experiences, gain your perspective. And you can see Morgan's email there, and I'm sure she'll put it in the chat as well. Next slide. All right, we are ready for questions. How are we doing this? All right. Morgan, are you reading us questions? Is that what's happening?
Yes, thank you, Melissa. So the first one that we got was in regards to the percentage of youth who had DCF involvement at time of detention. And someone asked, is there information about where youth are being arrested / context in which the alleged behavior leading to their arrest is occurring?
Oh, great question. It's like, did someone just try to set me up for this? So that is exactly one of the questions that we are seeking to look at in our study on dually involved youth. We are partnering with our colleagues at the Department of Youth Services and the Department of Children and Families to do a case file review. This information is not captured in structured data, like data on so many other things in the world that we might like to know about. And so we're going to be digging into case notes in these files to see if we can understand many things. But one of the things we'll be looking at is, where did the arrest take place? Did it take place at the youth's home with their biological parents? Did it take place at a foster care? Did it take place in congregate care, in school, in the community? And is there anything we can gather from the case notes that might help us understand the circumstances of the arrest, what might have happened before the arrest, sort of what were the behaviors, and particularly for youth in congregate care, were any de-escalation strategies attempted, things of that nature. So that is a long and intense study that we're working on, and we look forward to hopefully briefing you on the results of that in the future.
Thanks, Melissa. A second question, and I believe that this person was also referencing youth with DCF involvement, but if I am misunderstanding, please feel free to unmute and tell me that. But this person asks, for youth with DCF involvement, is there complete enough information to support an analysis looking for arrest patterns? For instance, where are the complaints and calls coming from, and are there opportunities to intervene, boost prevention in those contexts so that police involvement is less frequently perceived to be needed, and youth are more likely to receive supports they need without criminal justice involvement?
So this is Vera Morady, and I'm the one who put that in the chat. I wasn't actually focused on DCF involved youth. I meant for all youth. If we can find out what if there is a pattern in where some of these, especially for low level complaints, where these are coming from, I'm wondering if there's some need for supports for folks in particular systems to respond differently rather than picking up the phone and calling the police or, yeah.
That's a great question. Anytime anyone asks me if we have complete enough data, my answer is always no. We never have all the data and information that we would like to have. And I think in particular, we never have all the information we'd like to have at the very beginning of the system. Not to divert too much from your question, but folks always ask me, so arrests are going up. Does that mean crime is going up? I can't tell you, right? We don't have a database that tells us about youth behaviors. We only have a database that tells us about adults' reaction to those behaviors in the form of calling law enforcement. So I don't think we have the information, Vera, that you're talking about, as much as I wish we did. But we have been trying as much as possible to look at data by geography. And so we can at least see some patterns by county. It's not as granular as I would like, but that is sort of an area that we've been exploring.
And the final question we have, someone asked, is anyone currently doing or interested in developing a diversion program for kids engaging in problematic sexual behavior?
Oh, I know who asked that question. Joan, thank you for the question. To my knowledge, there is not currently a diversion program in the state that focuses on youth with problematic sexual behaviors. I think I would know if there was, but I always like to do that caveat because we're a big state and lots of things are always happening. But Joan, that is, as I think that's an issue that the Office of the Child Advocate is currently looking at, is what are our state's responses when children exhibiting these behaviors. And I certainly think considering the specialized diversion programs or how we might keep kids out of the juvenile justice system when possible is on the list. So I don't have anything for you just yet, but stay tuned.
Someone asked, do we have individual level data for all youth involved in the juvenile justice system, or is it aggregated as counts?
Yes. So while someone certainly has individual youth data, at least at different process points, we do not. Data is provided to us aggregated by process point. And so as a result, it does make some analysis difficult. We can't follow individual youth through the justice system. But we have it at enough process points that I think gives us a pretty good sense of what's happening out there. I'd love the individual data, though. I always want more data.
And that's all the questions we received in the chat as of now.
Great. Well, I just want to thank everyone again for attending. Oh, looks like Robert's got a question. Go ahead, Robert.
Okay, sorry. I know you're probably going to go have lunch or something. Good presentation. Information very, very informative. As you guys were sort of sharing this information, I was thinking about the work of Chambliss, talking about the Saints and the Roughnecks, and I was thinking about the work of Prevo, Peterson, where they're looking at race disparities, but they also include income level data. And when that income level data is included, the disparities between Black and white disappears in some of their models. And I was looking at the variables that sort of we were looking at here, and I didn't see anything that looked like income was also sort of being considered. Because of course, some of those, there may be some class implications in that, those differences between Blacks and whites and Latinos. And I think it's important to do that. I think it's important to also tell that story.
Mm-hmm. I appreciate that, Robert. So we do not have any data that would allow us to do that analysis. I'd love it if we could. I'm going to put my email in the chat. I'd love to see some of the research that you're talking about. I'd be very interested in that if you're willing to share. In general, we did talk about this general concept though in our report on racial and ethnic disparities at the front end of the system. There's nothing inherently there's nothing inherent about Black and Latino youth that makes them more likely to commit crimes, right? It's not like you get a genetic thing that happens that says I commit more crimes, right? There's other factors in our society that are going on, right? Poverty is certainly one of them. A variety of systemic injustices create situations in which youth might be more likely to commit crime. And so it wouldn't surprise me at all that the research shows what you said. I don't have any particular data that would tell me that that's what's happening in Massachusetts, though.
So the data that you guys, in other words, you guys don't have income level data.
Correct. We do not have income level data. Yep.
There's something else I did also notice, that the slide regarding revoked bail, reason why the bail was being revoked from juveniles, and I noticed that there was an increase in an unknown category. I'm wondering if you guys, if that sort of crossed anybody's radar.
Christy, can I get, yeah, thanks, Christy.
Christy's slide.
Yeah. Good catch,
and
Robert.
It was increasing the unknown category.
And some of that could also just be due to, I don't have an exact answer to your question, but some of that could also be due to a lag in just the data being entered. Because you can see that the increase was for fiscal year 23 and not necessarily previous fiscal years, but yeah, that's another, it jumped out to us as well.
Thank you.
Anything else? All right, I'm back to my thank you all for taking an hour at a sunny Friday to learn about the juvenile justice system. If you have thoughts and questions that you didn't have an opportunity to present, my email's in the chat. Tons of reports were put in the chat as well, and we would be happy to hear from you.